Hello, I'm attorney Dan Marr from the Nashua, New Hampshire law firm of Hamblett Kerrigan. I've been practicing here in New Hampshire for 36 years and in the Commonwealth of Massachusetts for 28. I'm going to be talking today in this vlog about what happens when you get subpoenaed or you're told that you're required to show up for a deposition in a case that you're not a party to. So maybe you're an employee of an employer that's being sued for employment discrimination or some other type of claim, and you're brought into that case because it could be a vendor having a dispute, or you're just a bystander and you were at a traffic intersection and an accident happened and you're being subpoenaed to be testifying in regards to that. Depositions themselves, when you get a subpoena or your boss goes and tells you you have to show up for a deposition, they're discovery depositions most of the time, so they're something that the lawyers on the other side are going to be asking questions, and you might have questions in regards to what's your protocols for this, and we're going to talk about that in this vlog. So first off, subpoenas, if they're served on you if you're in New Hampshire and you're served with a case that's in New Hampshire, a subpoena there, or in federal court there's a 50-mile radius of the federal court itself, or in Massachusetts, if you're in the Commonwealth of Massachusetts, you are served there for a deposition there, in the case there, then those are valid subpoenas. If on the other chains you get a subpoena for providing documents or to show up from a Massachusetts case in New Hampshire, they serve you up here in New Hampshire, you can talk to an attorney, but you can ignore it unless there's a specific way that they have to go through a certain process to be able to do that subpoena up here in New Hampshire. But a Massachusetts case, Commonwealth of Massachusetts case, can't go and serve a subpoena in New Hampshire and make you come down to Massachusetts for a deposition. Likewise, in New Hampshire, you can't, if a lawyer in New Hampshire goes and serves you down for a New Hampshire case down in Massachusetts, you live in Massachusetts, you're not required to come for that deposition. Usually you give a courtesy call to that person to let them know. I've had cases, even New York City attorneys that demand that absolutely they can do this stuff, and frankly they're strangely enough sending them to bank clients of mine. I don't know why they bother trying, but they're not allowed to do it. I also have people asking for institutional clients of mine to get some individual privacy records of the employees that are like in New Hampshire when they're a Massachusetts case. No, you're not going to provide it. But that's the lawyer dealing with it. For institutional clients, if you are an individual and you're served in New Hampshire for a case, by way of example, maybe you're down in Boston and there was an accident that happened and they try serving you up here in New Hampshire for a subpoena to come down to Boston to testify in a deposition, for a state court case, you generally don't have to do it. Second part of this is how you deal with yourself in the depositions themselves. You might have some discussion with lawyers, but the lawyers are going to be careful because if they're talking to you, anything that they say to you, like you may be aligned more to your employer perhaps, the employer attorney is going to be careful in what they say to you because anything they say to you can be discoverable generally. If you're a regular employee, if you're up or higher level in the company, sometimes they call it the control group, that's a different set of rules, but you'd be well versed with this by that time. Say if you're just a normal employee that's being called in as a witness, one of the things you want to think about carefully is don't answer questions that you don't know the answer to. This is not a suggestion of having a memory lapse. If you say you have a memory lapse and you don't have a memory lapse, you remember something, you are lying under oath. But if you are, just because the lawyer keeps on trying to push you onto something that you don't remember or you weren't part of, if that truly is the case, then you've got to be honest on this because you're going to be under there's criminal ramifications if you swear to something and you don't tell the truth. But don't get forced into saying something because the lawyer keeps on pushing you to say, how do you not know this? If you don't know it, you don't know it. And again, I'm not coaching you to say you have a lapse of memory. If you remember something, you say it, and maybe you're caveating. I think I remember this. I'm not sure, but I think I recall this. Whatever you say is fine. And if you remember something crystal clear, you say, I remember it crystal clear. This is the way that happened. You want to also be concerned about the lawyer asking you for personal information. I've had, when I'm on the other side of cases down in Massachusetts, I see standard, they ask for the Social Security number for the witness, and they say, well, this person may not be available. I always object when I'm on the other side because I think it's abusive. But certainly in New Hampshire, it's not the custom up here. And if there is somebody that goes and asks you for your social security number or some real personal information that's not relevant to their case, like you're an employee of a company, or you're and there's something dealing with the employer that's not related to you, or you're you accident witness, you generally don't have to provide it. And if the lawyer threatens and says they're going to get fees from you, don't worry about it. If they're trying to ask for their personal information like that, the judges aren't going to be inclined to do that, and you're not going to get fees against you because you won't provide your social security number to somebody you don't know across the side on the other side. So be careful. Don't be obstructionistic. Tell the truth. Think carefully about the answers you're asking. If you don't understand the question, don't feel like you're being stupid. Say, I don't understand the question. Have them rephrase it in a way that you do understand it, so you know what they're asking about, and then you can honestly answer the questions appropriately. So if you have questions in regards to this, I'm happy to talk to you. I'm at 603-883-5501, Dan Marr, 603-883-5501. I've been, again, practicing for 36 years, and you can check out my weekly vlogs. Go to nashualaw.com. Go to the topic. You can search by topic by going to my bio and then click to my vlogs, and you can go by the topics of interest of yours. And again, I've been doing these weekly, so there's quite a few of them out there. Happy to help if the opportunity arises, and I hope you don't get the post, but I'm required to be coming at deposition, but if you do, it's a relatively painless process. And my experience with the vast majority of the lawyers, both in New Hampshire and Massachusetts, that they're professionals, and they will treat you with respect. And if, I was only talking about some of the issues that sometimes when some lawyers cross the line. So please give me a call, 603-883-5501. Thank you.